app store, what can a small company do if you have an app that's successful and some rival app, like you're saying, copies the idea, but
Sure.
this organization is in India or Pakistan or China or whatever your
Sure.
country is that doesn't really enforce trademarks or intellectual property so much?
Yeah, I think it kind of depends on the app store you're in, right? So if you're in the Google App Store, it tends not to be as policed as say the Apple App Store. I think we usually recommend, and I should caveat all this, that all these things sort of vary sort of circumstance to circumstance, and none of this advice is sort of we're not here giving sort of specific advice on things, but to the extent that you're talking about, we often encourage folks to go first to like Apple, right? If you think somebody else is sort of pawning off on your name or infringing, your first contact maybe should be to Apple if you're in the Apple App Store. Yeah.
All in the back there.
Piggybacking on the same question.
Yeah.
Don't you think it's like going back to say .com, for example, eBay, there are like a lot of eBay sites across the country. We can't go after them because it's a different country laws and everything, so we can't go across all those companies which are there. The best thing that they can do is just buy out those companies like what eBay and Amazon does. For example, Baidu is there, and there's another site called Barbie.com, which eBay bought it back in India.
Sure.
So I don't think we can do anything at this point too, right? If there is another app coming in India or Pakistan, suing their own country.
Well, so maybe I'm not following the.
Or actually, it can police it because it's across the country.
Yeah, you can enforce cross-country. Now, many, just sort of getting back to the idea that it depends on what we're talking about here. If you're talking about somebody sort of pawning off something that looks very similar to your app in the App Store, your best bet may not necessarily be to seek go the sort of legal file a suit remedy. Often like an Apple will have a process where you can file you can file and complain about somebody who has something that looks awfully similar and sort of go after that. That's often a much more effective remedy than attempting to, say, sue in another country, or particularly if you haven't registered your trademark right in that country. Or yeah, I would agree that the cross-national the international flavor of and the speed with which IP sort of flows cross borders these days is makes enforcement a challenging thing. That's not to say that if there are enough dollars involved and if folks have properly filed trademarks and gone out and registered in particular jurisdictions, it would allow you could go and seek enforcement. So yeah.
Let's narrow it down to two more questions. He's had his hand up in the back there.
Yeah, what kind of advice do you give to people who are going to be working with or rolling out an idea to a prospective partner, but they actually are a friend? You have good rapport with them, and so it's this socially awkward space where you want to present an NDA just to protect yourself, trust but verify kind of thing, but they're a really good friend. And then how do you navigate that complex dynamic that you talked about where you want to disclose some idea details and engage in a creative brainstorm, but you don't want to go too far because of...
I think it kind of comes down to, is this person going to become a founder with you, right? I think it's a different analysis if this person is merely a sounding board or somebody who may in the future participate in some ancillary capacity in the business as opposed to being a founder with you. If they're a founder with you, there's a sort of a natural amount of sharing that has to take place.
And I think a little bit your question was, and I think the gradation, is this somebody you're just using as a sounding board? You may want to just talk about the global concept and see if there's an interest in it. If this is somebody who you think would collaborate with you and they would be adding, you have an idea and you have a certain capability, and they can add to it and become a partner, a 30%, 40% contributor to an end product. Without them, you wouldn't have the ultimate end product. Then you've got to negotiate what's a fair arrangement, and you don't want to tell them everything so that they just take what you have and run with it all on their own. But you start, again, I always say, like, we talk about open the kimono, open it very slowly. Just only disclose what you need to disclose. That's my golden rule with my clients. Only disclose to the extent you need to disclose to get to the next inflection point with the person you're having discussions with, and that you may want to have a business arrangement with. Now, the other person you could be talking about is a friend or someone like that who works for Apple, and very high up, senior executive vice president, or someone at 3M, or stuff like that. That you got to be very careful that you don't over-explain something that they sit there and say, hey, friend, but I can take this and get a $200,000 bonus for passing it on within my company. So you always have to evaluate. Why am I about to disclose the information that I have internally, my trade secret? Why am I about to disclose that to Joe here, or to Yermo, or to Sanjay? And in each case, I may be disclosing it to him because he's my counsel. I may disclose it to him because I want him to be my partner. I may disclose it to Joe here because his company may want to buy me. And in each case, I have to evaluate, what do I want to disclose to them, and what's the risk that they will do something harmful with the information I give them. And there's a different risk. There's a far lower risk here because he has malpractice insurance involved, and I can sue him for taking my idea. I may disclose a lot more to my counsel than I would disclose to these two guys.
There was one question right here, right?
Yeah, I was going to say, I've been to the Apple trademark dispute process, and the way it works is you send a cease and desist letter to Apple and complain, and then Apple contacts them, and basically they have about 4 weeks to work it out with you. Otherwise, Apple takes them down. And so there's no fighting with Apple. Apple says, I'm not going to judge a jury, and if they don't work it out with you, they go down. And so I guess you run that risk too. If somebody complains about you, you got about 4 weeks to get it sorted before you go down.
All right, let's give our panelists a round of applause.